In considering Sheehan versus Flower, the Arizona Court of Appeals ruled grandparents are not entitled to rights to object to a custodial parent's out-of-state relocation with their child. After a dissolution of marriage between the child's parents, mother was awarded sole legal custody as well as primary physical custody of the party's child. Father was awarded 4 hours of parenting time every other week, with his mother, the child's grandmother, acting as a supervisor for those parenting time sessions. Grandmother was granted visitation with the child after she filed a petition in April of 2004 with the court, and the court awarded her 4 hours of visitation following father's parenting time. Grandmother was also allowed to see the child during the time father had his parenting time scheduled. In December 2005, mother advised that she and her child would be moving to Indiana in order to care for mother's ailing relative. Grandmother filed a motion with the Superior Court of Arizona to prevent the child's move to Indiana. Her motion was based upon Arizona Revised Statute Section 25-408, in which procedural safeguards are granted to a non-moving parent of a child to object to and possibly prevent that relocation of that child. Grandmother claimed mother's only purpose in relocating with the child to Indiana was to prevent her from exercising visitation with her grandchild. The Superior Court ordered both parties to file briefs explaining how the specified law would apply to a grandparent's visitation in relation to a parent's request to relocate to another state. After considering all the pertinent information, the Supreme Court concluded that Arizona Revised Statute Section 25-408 does not apply to grandparents' visitation rights. As a result, the court directed the parties to participate in a conference call to discuss the grandmother's long-distance visitation plans. The court also set a date for trial in case the parties could not reach an agreement on grandparents' long-distance visitation with the child. At trial, grandmother's visitation schedule was ordered by the court. She appealed that order. On appeal, grandmother claimed the trial court misinterpreted Arizona Revised Statute Section 25-408 and that she is, in fact, entitled to the procedural rights and safeguards afforded within the statute to prevent mother from relocating to Indiana with her grandchild. The Arizona Court of Appeals affirmed the Superior Court's determination that Arizona Revised Statute 25-408 does not apply to grandparents' visitation. The law states that advance notice and related rights are afforded to a parent when their custody or parenting time will be impacted by the primary residential parent's relocation. The Arizona Court of Appeals held that the common meaning of the language, similar statutes, and case law all point to a parent being distinct from and excluding a grandparent. Thus, the plain language of Arizona Revised Statute Section 25-408 does not apply to Flower's grandparents' visitation. She was not, therefore, entitled to avail herself of the protections to prevent relocation provided in Arizona Revised Statute Section 25-408.